Did you know that if you're selected as a juror in a medical malpractice case, in an accident case, even a wrongful death case in New York, the judge will tell you you are not permitted to use text, tweet, Facebook, or your iPhone during the course of trial? Would you like to learn why? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial attorney practicing law in the state of New York. Today I'm coming to you from Orlando, Florida, and I'm at a seminar, and I have a few minutes to share with you this great information. At the beginning of every case, the judge is going to tell you, listen, you are not to go online, you're not to do your own research, you're not to use your iPhone during the trial to learn more information about what's going on during the trial. Why not? The reality is that the judge does not want you to get some outside influence that's now going to affect you when you go ahead and come to a decision or a conclusion about who's right and who's wrong. And I have to share something with you. Every single judge in New York will give you that instruction. But we know over the course of the past few years, there have been jurors who have disregarded those judicial instructions to their detriment. And what's happened is that the jurors would then tweet during the middle of a trial, they'd be on Facebook on their iPhone during the middle of a trial, and then all of a sudden, whatever verdict they rendered ultimately becomes overturned. Why? Because they disregarded what the judge told them to do. Now, let me share something with you. This is my own personal opinion. In today's day and age, I honestly believe that jurors should be allowed to go ahead and use their iPhone to text, to tweet, and use Facebook. And I'll tell you why, and it's not for the reason you think. I think that we should allow jurors to use this. Why? To communicate with the attorneys and the judge. Now remember, here's why I say that. During the course of trial, the jurors must sit quietly and listen to all the testimony, listen to all the questions and answers. They must listen to all the evidence that's being put in. Rarely do they have an opportunity to raise a hand and say, excuse me, Mr. Attorney, I didn't understand what that witness said. Could you explain? There are some judges in New York who will allow jurors to ask a question, but there's a whole process to it. They raise their hand, they write down a question on a piece of paper, it has to be submitted to the judge has to decide whether it's an appropriate question, and then make a determination whether to ask the witness or the attorneys the question. I think a simpler way to do things is to allow jurors the ability to ask questions while testimony is going on. This way the attorneys can find out what they're not asking. What are we leaving out? What do the jurors really want to know, so that now we can go ahead and ask the witness before they leave the key questions that the jurors really want to find out. And obviously, if there are things that are inappropriate, the judge will prevent the attorneys from asking the question. But this way, it would allow the jurors the ability to actually interact with the attorneys, interact with the court, which would then give the jurors the answers to the questions that are going on in the mind as they're listening to testimony. The reality is that I don't think this is ever going to come to fruition, certainly not for a good number of years. So why do I share this great information with you? Well, I share it with you for two reasons. One, just to teach you about what happens when you become a juror, and two, to give you my ideas and my thoughts about what we probably should be doing to allow jurors to interact with the attorneys to get a better understanding of the testimony and of the evidence being presented. Well, that's it for today's quick video, and as always, if you have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions if your matter happened in New York, and if it didn't, then I might be able to refer you to a trusted attorney in the state where you are. Well, as always, you can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's quick video. I'm Gerry Oginski coming to you from Orlando, Florida. Have a wonderful day.